Hello, everyone. My name is Chris Smith. I'm a shareholder with Maynard Cooper and Gale here in our Huntsville office. I practice in our corporate and securities practice group, and in that role, help do everything from set companies and clients up on the front end of their life cycle, help them with sell events later through M&A activity, and really anything and everything in between through that process. And one of those big in-between items that every company has to deal with are contracts. And that's what I'll be talking about today. And contracts are really, in the corporate world and the business world, they're one of those things that I think are very underappreciated and often overlooked. To make a sports analogy, they're kind of like an offensive line in football, right? You don't know a lot about them, and you take them for granted. But if you've got a bad offensive line, if you've got bad contracts from a corporate perspective, it's going to cause you a lot of problems, and your competition is going to take advantage of that. So, with that, let's get started on the PowerPoint. Okay, so just a broad overview of what we'll talk about, and this is really just a kind of a 50,000 foot view of the topic of contracts, but we'll talk about what a contract actually is, go over some of the types of common contracts that most companies can expect to run across, and then walk through some of the key terms and provisions that we see in contracts so that you can kind of know what those provisions mean and kind of get some insight for how to tackle those. So first of all, what is a contract? A contract is an agreement between two or more parties that involves a meeting of the minds on material provisions. They commit each party to do certain things, some obligations, and with a few exceptions, they do not have to be in writing to be binding. There are some exceptions to that. And certainly, ideally, all of your contracts are in writing so that they're what they mean. You can put your hands on them. But there's no magic to what they're called. But what's important is what's in the actual document itself. And as we'll talk about in a few minutes, contracts come in all different shapes and sizes, and it doesn't really matter what the title of the agreement is at the top of the document. What matters is the actual binding contractual provisions that are contained within the document. So why are contracts important? They outline the relationship of the parties by specifying each party's rights and obligations. They obviously provide contractual protection to each of the parties and prevents, if drafted properly and correctly, they also help to prevent misunderstandings between the parties to the contract about what the obligations are and what each party is supposed to be doing. And, I'll back up for just a second. Oftentimes, parties, even sophisticated clients, may not think about their contracts until there's a problem, right? I mean, you worry about the business side of the contract. What are the services or the products or the goods or anything else that's being provided or received by each party to the contract, but you don't think about, worst case scenario. You don't think about what happens when things go wrong. And unfortunately, but inevitably, things do go wrong. And as soon as things go wrong, people want to go and pull the contract and then see what it says then, right? Instead of being proactive and thinking about all the different possible scenarios on the front end of the negotiation that if they had thought about that, maybe could have put themselves in a little better position. So regardless of the type of contract that we're talking about, most contracts kind of have a certain structure and a certain way that they're built. And normally they start with an introductory paragraph that identifies who the parties are to the contract and specifies when the agreement becomes effective, right? That's it seems basic, and it is, but it's important to know exactly who the parties are to that contract, because if someone is not a party to that contract, they're not going to be contractually bound by those provisions, and with a few exceptions, are not going to be able to actually enforce the provisions of that contract. So again, while basic, it is an important piece of the contract. And then you will see normally a recitals or whereas clause. These should give the background on the contract, who is giving what to whom, what are they getting in exchange, and why are they doing that. Anyone unfamiliar with the agreement should be able to look at the recitals and know the basics of the agreement. Essentially, what a good recitals clause does is tell the story of the contract. It tells, how did we get here, and why are the parties actually performing under the contract. And you may think that sounds silly or unnecessary, because you negotiated the contract. You know why you're entering into this agreement. But understand, many contracts go on for years, 2, 3, 5, 10 years, longer. In that span of time, the different people involved with the organizations that are parties to that contract can change, right? So the people within your company who worked on the contract may not be with your company a year later when an issue comes up or someone needs to figure out what is happening with a particular contract. And so what a good set of recitals do is help allow someone who may not have been involved in that process, someone who is unfamiliar with the agreement, be able to pick that up, read the recitals, and get a pretty good background of what the parties were doing. And also, even as legal counsel, that's very helpful. If we weren't involved in helping negotiate the contract, or we're helping to provide some advice about what the contract means, it makes it it's very helpful for us, and makes it much easier for us to get up to speed on what's going on if we can read those clauses and get an idea for what the party's background was entering into the agreement. So, you kind of have, after those initial provisions, you have what I describe as substantive provisions and standard provisions, and we will kind of walk through each of these in a few moments. Substantive provisions are things that they will generally vary pretty widely from contract to contract, depending upon what the nature of the contract is. You have obligations of the parties, payment provisions, representations and warranties, indemnification clauses, and term and termination. And then you'll have what I call standard provisions. And don't make the mistake of thinking that because I call a provision standard that it's not important. They are. They're extremely important. But these provisions, from a look and a flow standpoint, tend to be similar, at least from a structure standpoint, from contract to contract. So before we kind of dive into those specifics, I thought it'd be helpful to just go through a few, just general words of wisdom when it comes to dealing with contracts, especially if you don't have much experience, with contracts, and you're looking to, to kind of, start on the right foot. First and foremost, and this, it seems silly and it seems obvious, but the most important part of any understanding of a contract is to actually read it. You are, by signing a document, by signing a contract, you are obligating yourself to certain things. And it's so important for you to read that contract and understand that contract to make sure you understand what you're signing up for. And I know that we've all been in the position where we're maybe signing a lease for a car, or signing bank documents for a house, where you're thinking, good grief, do I really have to go through and read all this stuff? And I understand that a lot of times people don't do that, but I'm just telling you that if you can really read the contract and understand it, it will certainly help you out in the long run. And the role of attorneys in this process, and I'll just ask that you take me at my word for the fact that I'm not trying to sell you services in terms of using attorneys, including me, for help with your contracts. But attorneys can do a couple of different things for you. Number one, they can help negotiate the terms of the contract in such a way that it puts you in the best position possible. right? It helps you, if there are trap doors to a contract, if there are things that maybe a business person does not know about, attorneys are obviously helpful in helping you navigate through those things. But it's important to know, just know and understand what the contract means, and that goes back to reading the contract. A lot of people tell me, especially people who are just getting into the business world, who are just forming their companies, who are just getting started. They tell me, listen, I'm a new startup. My negotiating leverage in the contractual process is not very big, right? I'm getting agreements put in front of me by monster parties, monster companies on the other side. There's no way they're going to actually, take my suggestions or give me things that I'm asking for. And what I tell them is that may very well be the case, but it might not. And the only way to know is to ask some questions and to try to get some changes. But even if you can't get any changes made, if it really is a take it or leave it type contract, then you need some help in terms of evaluating what you were agreeing to, right? I mean, if you're stepping into a bad situation, it's good to know what that bad situation is on the front end, as opposed to the back end when something goes wrong and you don't know, contractually what is supposed to happen. The danger of ambiguity. It is so important to make sure that the provisions of your contract are clear. And I know that a lot of people like to joke that attorneys have a habit of making contracts more complicated than they need to be. I get that joke, but our goal and my goal when I work on a document is to make sure that things are as clear and as simple as possible. And you want that obviously for the parties to the contract, because it's obviously a major issue if you've signed an agreement and your obligations or the other party's obligations under that contract are not clear. I mean, that's that is a failure if the contract does that. But more practically speaking, if a third party is looking at the agreement later, whether it's a dispute, a successor party, if your company's been bought by another company, or if there's litigation, if a judge or a jury is looking at that contract, it's good to remove the ambiguity so that there's no room for debate. If a contract is not clear, if a contract has ambiguity, if there's room to make arguments about certain points, then if there's a dispute, you better believe that different parties will take different positions. So the more clear you can make your contract, the better. A couple of other just kind of common things, and these are really, these are logistical, practical contract issues, but they're things that I see every day and things that cause problems when they really shouldn't. Number one, execution and signing of the document. Make sure that the contract gets signed by each party thereto. Make sure that it's signed by someone with authority, and include the printed name and title of each person signing. So see this all the time. The parties negotiate an agreement, final drafts are circulated. There's an assumption made that everybody has signed the agreement because maybe there's some emails that have been exchanged agreeing to the form of the contract. But then, a year later, 2 years later, when an issue comes up and the parties are looking for a signed copy of the contract, they can't find it, right? And again, that can cause some pretty serious issues in terms of, do we actually have an agreement in place, right? And that's obviously not the questions you want to be asking yourself at that point. So do your diligence, make sure that even though the form of the agreement has been agreed to, that everybody actually signs the agreement. Again, I see this all the time. It just happens, unfortunately. Number two, signed by someone with authority. That is it's a smaller issue and we don't see it very often, but certainly if someone is signing an agreement on behalf of the company, then it needs to be someone who has authority to do that, right? Someone who has authority to actually bind the company. It doesn't need to be your mail clerk or someone else who's not in a position of being able to bind the company. It's less of a concern because at the startup phase, right? I mean, you may be a company of one, and so in terms of authority to sign may be less of an issue, but it's still good to kind of keep that in mind. And, on the signature block itself, a lot of contracts that are bad contracts just have a single blank line where each party signs it. My handwriting is horrible and has gotten progressively worse over my 17-year legal career. And so that's the case with a lot of other people as well. And that's why it's important to include the printed name of each person and their position signing it, right? So that it's Christopher E. Smith signing the document on behalf of Maynard Cooper and Gale, and you're not trying to guess who that person is. And again, this all comes up not at the time of signing. This is, as you can see, a recurring issue. It's the issues that come up later, a year after, 2 years after, 3 years after a contract has been signed. People pull the contract, they see a signature on it that binds a company, and they can't tell who in the world it is. So again, small things like including that name in the title, help go a long way. Filing and storage. You want to keep a file for each contract, including supporting documents, and you want to have a system in place that helps you track whatever your contractual obligations are. Again, keeping the file, that goes back to if someone's unfamiliar with the contract, just having kind of backup information that shows how you got to the point of signing the contract. And then tracking your obligations. It can be easy, once you get to the finish line of negotiating a contract to just kind of throw it in the file and forget about it. Well, it's important to make sure that any ongoing obligations you have under that contract, you're tracking and keeping up with. A good example of that is the termination provisions in many contracts. A lot of times there may be, if you have a 1-year contract, it may have an auto renewal provision where if you don't give notice within X number of days of termination, it automatically renews for another 1 year, 2 years, et cetera. So, if you've got that provision in there and you want to get out of the contract, it's important that you know when that date is. Otherwise, you could find yourself signing up for another 1, 2, 3 years more of contractual obligations that you did not want. So that's just a good example of making sure you're keeping your eye on what those provisions are. So let's talk about some of the common types of contracts. This is not an exclusive list by any means, but these are, what I'll call kind of the most common types of agreements, especially at the startup phase, that you can expect to see. Non-disclosure agreements or confidentiality agreements provide for the sharing of confidential and proprietary information and how such information is protected once it is shared. It's important to keep your information secret and prevent the other party from using or disclosing your information. And that's, these are documents that you should always think about at the outset of any type of discussions with another company or a third party about your company, right? You want to make sure that anything that's exchanged, any information that you provide that is of a proprietary nature, that there's a contractual obligation that the other party keeps it confidential, keeps it secret. Without that, you're out there just volunteering your information to anyone who's there to hear it, and that's certainly not a good thing. Non-disclosure agreements, NDAs, they can be unilateral, which means there's an obligation only one party to keep information secret, and then a mutual agreement where both parties are under confidentiality obligations. And you may ask yourself, well, and I run into this with clients, and I see a lot of other attorneys who do this as well. They just, make every NDA a mutual obligation. So any information that's exchanged by both parties has to be kept confidential. And that, again, at the surface level, that makes sense. And in many cases, that is completely appropriate. However, if it's a situation where only one party is actually providing confidential information, then I like to make sure that that's a unilateral agreement, right? Because if you have a mutual agreement, there's some maybe misunderstanding about who's providing what, right? And so again, if I don't want to create any arguments that we've somehow disclosed confidential information if we haven't. So again, look at the situation. If both parties are going to be providing that type of information, then a mutual NDA is completely appropriate. If not, if only one party is doing that, then the unilateral agreement is appropriate. The key thing to remember is, again, at the outset of any type of business discussion where you may be disclosing that type of information, you want to make sure that you've got an NDA in place before those conversations begin. Service agreements, agreements between a service provider and a customer where the service provider agrees to provide a specific service to the customer. You know, these are very common, right? Most companies need some type of service provider, whether it's a consulting agreement, professional services agreements, otherwise. You know, this is not an exhaustive list at all, but things that you should include are a good description of the services to be provided, identify who's actually going to be providing those services, the schedule or frequency of when the services are to be provided, and obviously payment provisions and when and how those take place. Another thing to have in a good service agreement is a standard of care. And what I mean by that is, you know, if let's just say you're signing an agreement for a lawn care company to come and take care of the lawn that you have in front of your facility, you know, they can come out there and perform the service, but do a bad job doing it, right? I mean, you want some type of standard of service where they're going to do it in like a good and workmanlike manner. They're going to do it in accordance with acceptable standards and things of that nature. You know, so essentially set some type of standard that service provider has to meet in terms of providing that obligation. Purchase orders are a very common contract where, you know, where one party is purchasing goods, or it can be services from the other. They can incorporate terms and conditions of a larger master agreement or standard terms and conditions. And that's where you have to be really deliberate. Purchase orders are very common and are many times just accepted without even reading them. And many times in small print, unfortunately, they will incorporate, again, this bigger list of contractual terms that may not have been included in your actual purchase order. Again, going back to that initial set of recommendations, make sure you get whatever other terms and conditions are attached to that, just so you can understand what you're signing up for. Then there you see some minimum pieces of information that purchase order should include: quantity of goods being purchased, the fee or payment provisions. Yeah, you're going to have that in every contract. You're going to make sure you lay out how the appropriate party is going to be compensated, and then shipping and delivery information as well. Another common document is a bill of sale, which records the transfer of ownership of a particular asset to a second party for the exchange of money. You know, some of the kind of blocking and tackling terms that should be there are a precise description of the asset being purchased, the amount paid for the asset, and then certain representations and warranties. And we'll talk again in just a minute about what representations and warranties are, because they are a very critical part of any contract. And then finally, a lease agreement. It's an agreement between a landlord and a tenant that allows the tenant to occupy a certain space. I'm sure you all knew that already. Lease agreements are very common for, you know, taking on different space, and are a big part of what our real estate group does here. You know, and you see some terms there that should be included. It's obviously, as with every other contract, it's extremely important to make sure you understand the terms of your lease, that you negotiate terms that put you in the best possible position, and make sure you know what those obligations are before you sign on to them. So key terms and provisions. There's no way, you know, the good thing about contracts is that, you know, if you can dream it, you can do it, right? I mean, if you've got a piece of paper and a pen or a pencil, you know, you can lay out, you know, any business terms that you want, contract terms, and sign on to those. But you know, we do see kind of over and over the same types of provisions that come up. And the most important part of any contract, and don't let any attorney tell you any different, are the actual business terms of the agreement. You know, these include the basic terms of the contract, the price, the quantity of goods or services, scope of services. And it's extremely important that the business terms reflect the party's understanding. And, you know, anytime I'm having a conversation with a client about either a contract that they are wanting to get into place or a contract that they've already signed, is to ask them, you know, what is this contract supposed to do? Are you selling goods? Are you buying goods? Are you providing services? Tell me kind of what the parties have agreed to, and whatever that agreement is from a business standpoint, it should be reflected accurately in the contract to reflect the parties' understandings. That is without a doubt the most important piece of any contract, because at the end of the day, that's the why for why you're entering into the contract in the first place. Representations and warranties. So I tell clients that there are certain provisions of every contract that when you see them, you should immediately, a red flag should go up, and your attention should be drawn to them, and you should really pay attention to those provisions. And representations and warranties absolutely fall within that category. A representation is an assertion of fact, which is given by one party to induce another party to enter into an agreement or take some other action. And a warranty is a promise that an assertion of fact is true. If those sound very similar, it's because they are, right? And today, they are almost used interchangeably. But at the end of the day, what representations and warranties are promises. They're promises that one party is making to the other party, and they're extremely important, because if those promises turn out to not be correct, then that's a breach of contract, right? You have breached your agreement, and that can subject you to damages and for amounts you have to pay later. So here's a sample provision. Seller represents and warrants that there is no suit, action, proceeding, or investigation pending or threatened against seller. This is a litigation rep, right? So the seller is essentially promising the other party in the agreement that they're not a party to any type of lawsuit out there, right? And that could be very important to the other side in terms of their confidence in contracting that party. So if the company making this promise has been sued, if that is not accurate, then that's a breach of contract, right? You have agreed to a provision, and you have violated that because it's not true. A lot of times, especially in larger contracts and company sale contracts, the representations and warranty section will be pages upon pages upon pages of promises. And in a provision like this, clients get a little worried and upset that, oh my goodness, that's not true. I have been sued. I've got multiple lawsuits that are out there. How can I sign this contract? The goal of representations and warranties, the goal of these promises are to lay out an accurate picture of kind of what the business deal looks like at the time the contract is signed. So if it's not true, what you would do is you would disclose those lawsuits, right? So you would say, except as set forth on Schedule 1, there are no lawsuits or other proceedings. And then you would list on that schedule what those are. It's a good information gathering technique for both parties to kind of smoke out any potential issues that might be there, and again, help them understand what the realities of the situation are before they sign the contract. In the case of this litigation rep, it may not be a big deal at all that a couple of lawsuits are disclosed, or it could be a major deal, right? It could be a deal killer. It's just important to get those things right, because these representations and warranties tie into the next provision, which is indemnification. Indemnification clause is an express contractual remedy that allows the parties to shift risk. It's an undertaking by one party to compensate the other party for agreed damages, costs, and expenses, typically stemming from third-party claims, but not always limited to third-party claims. It reduces uncertainty and manages liability risks, and they are heavily negotiated. Representations and warranties and indemnification clauses are often the two most hotly contested, hotly negotiated contractual provisions out there. So indemnification is essentially a promise to make another party whole for damages they've suffered due to your actions, right? And you'll see a sample provision at the bottom. Agent shall indemnify and hold harmless the company from and against any and all liabilities, losses, expenses, and costs that the company may sustain or incur as a result of the service provided by agent hereunder. Okay. So again, you get to those representations and warranties that I talked about before. If you've made a promise under the contract and you've breached that promise, and because of that breach, the other party has suffered damage, right? They've been pulled into a lawsuit. They've been, forced to pay amounts due to that breach. By agreeing to indemnification clause, you're agreeing to step in and make them whole, essentially pay them the money for the damages they've suffered. This is how you have to pay money under a contract that isn't part of the business deal. This is how you suffer damage and you have to make someone else whole. This is we could talk for hours about representations and warranties and indemnification, but for the sake of brevity, I will just say these are two very important provisions that when you see them in a document, your attention should immediately be up, that you need to be on the lookout for those provisions. You need to read them carefully. You need to understand what promises you're making. You need to understand what your obligations are if one of those promises turned out to be wrong, and the other party of the agreement suffers damages because of that. Extremely important. And again, my suggestion is make sure you have an attorney involved to help walk you through that process and help you understand what it will mean if these provisions come into play for both sides, right? You can certainly be on the other side where the other party has breached a provision of the agreement, and you may be entitled to indemnification from the other party as well. So they're important no matter which side of the contract you happen to be on. Limitation of liability. It's a clause. It's an express contractual remedy which limits the liability of one or both parties. It can include a liability cap or a waiver of certain damages. This is another provision that's often heavily negotiated. Comply to the contract as a whole, or just specific terms of the contract, or an individual transaction or piece thereof. And a sample provision there is, in no event shall the seller be liable hereunder for any consequential, exemplary, punitive, or special damages. It's important when you sign an agreement. I mean, obviously, you're going to make sure that the business terms are correct. If I'm selling goods to someone, then I want to know, what my obligations are and what the amount of money is I'm going to get for those goods. And the same thing for the other side, right? They want to know what they're going to have to be paying to get those goods or services. What you don't want to do is sign a contract that subjects you to potential liability that's far above and beyond what the benefit is you're getting under the agreement, right? So if I'm signing an agreement to provide services and I'm being paid $100 under that contract for those services, that's fine and great. But if I'm signing up for a potential liability that's $10,000, that's obviously a problem too, right? So it's good to I'll say it depends on which side of the contract you're on. If you're a party who's going to be subject to indemnification, or if you breach the contract or don't perform your obligations, it would be great to have some type of limitation of liability provision to limit what you have to pay. In a lot of cases, you'll see liability limited to amounts actually paid under the contract. So in my original example, if I'm only paid $100 under the agreement, then the most I would have to pay back is $100. Or you can limit liability to insurance coverage, right? So if you have insurance in place that would cover a particular claim, you limit that to only those amounts so that you don't have to pay any additional amounts above and beyond what the insurance proceeds are. If you're on the other side of the equation, if you're suing the other party to the contract or the other parties to the contract, you don't want to see a limitation of liability provision, right? You want to be able to recover whatever the amount is you've been damaged, regardless of how much you paid under the agreement, or regardless of what insurance coverage is. And so it's a very important provision. It's one that the parties immediately look to if there's been an issue under the contract. And it's obviously very good to know, what these provisions are on the front end of contracts, so that you understand, either you have some protection from a liability standpoint or that you don't. Force majeure clauses have been extremely debated and an extremely hot topic over the last 12 months for obvious reasons. A force majeure clause excuses a party's failure to perform under the contract to the extent such failure is caused by a force majeure event outside of the party's control. These are those acts of God type things. So, if you're supplying product, but your manufacturing facility is wiped out by a natural disaster, a tornado, a hurricane, whatever it may be, you could point to your force majeure clause and say, hey, I didn't perform under the agreement, but I couldn't do so because of this unpredictable, unpreventable event. Labor strikes are another good example. Pandemics and epidemics can be included, and obviously, with the COVID pandemic this last year, we were getting calls on a daily basis about force majeure provisions, and we were getting them from both sides, right? We were getting them from companies who could not perform their contractual obligations because they couldn't work, they couldn't send their workforce in, and they were worried about breaching their contractual obligations. Well, the other parties to the contracts, were calling us also because they wanted performance under their agreement, right? They didn't want the other side to be able to say, we can't deliver because of this situation that's going on. And in a lot of cases, it really depends on the actual provision itself, right? Not all force majeure clauses are created the same. Some are much more specific and limited. And some are very broad and all encompassing. And you'll see an example provision here at the bottom of the slide. In the event that a party is unable to perform its obligations under this agreement due to a pandemic, epidemic, governmental order, or other cause outside the party's control, such party shall not be liable for damage to the other party as a result of essentially a breach. This is a very it's what I like to see if I think a force majeure event could help my client. It's the type of provision I like to see because it's broad. It provides some specific information, but it has this catch-all of other causes outside of the party's control. That is extremely broad, right? And that could, if you're on the side of the contract that's receiving, products or services, you're going to want to limit that. But again, it all goes back to how broad or limited is your provision, and being aware that, especially in today's world, if you're a supplier, a manufacturer, if you're providing goods or services to a third party, you want to make sure that you have some protection from a contract standpoint in case something like this comes up, something that's not predictable, and something that is outside your control. Termination provisions, again, very important pieces of contracts. They detail the circumstances under which a party can terminate a contract and discontinue its obligations. You see some just examples of common types of events that would give rise to your ability to get out of a contract. Mutual agreement, breach, things of that nature. And that's, it's one of those areas that's I think taken for granted. But you definitely want to know what the termination provisions are. Can you get out of the contract if something goes wrong? Are there, if there's a breach, are there cure rights, days that the other party can come in and try to fix those issues? And again, a sample provision here at the bottom. This agreement shall terminate upon the earlier of 1 year from the effective date, or execution of a definitive written agreement regarding a transaction. So this is obviously taken from like a memorandum of understanding or a letter of intent or some other type of initial document that's meant to set the stage for a more robust document down the road. But again, just knowing what your termination rights are there. An assignment clause generally prohibits a party from assigning or delegating any of its obligations, rights, and duties under the contract to a third party. Should require the party to give prior notice of such assignment. May not want another party to step into the shoes of the other party. So this makes sense, right? And this is one of those common provisions that you'll see in almost every contract. If I sign a contract with ABC company to provide certain services to me, the last thing I want to do is give ABC the right to just go out and assign their obligations to somebody else, right? I don't know who that other company is. I didn't negotiate my agreement with that other company. I have no idea if they could do a good job or a bad job. I don't want them to have the ability to just go out and be able to do that. And so most contracts will have some type of an assignment restriction. It'll either be an outright restriction or will require the prior written consent of the other party. Very common. And you see an example there at the bottom. Neither party may assign, transfer, or delegate any or all of its rights or obligations under this agreement. Again, this is assignment provisions fall into the category that a lot of people call boilerplate, which means that which means that the parties don't pay attention to them until they actually want to assign the document, and they go back and really hope that whatever their goal is matches up with what the assignment provision in their document says. Dispute resolution. So nobody enters into a contract thinking that things are going to go wrong. I mean, otherwise, why would you enter into the agreement? But I can attest to the fact that, unfortunately, in many cases, there is some type of disagreement that needs to be resolved related to the contract. A good dispute resolution provision will set out the mechanics and the mechanism for how those resolutions will be resolved. And again, believe it or not, there's a lot of different ways the parties can go about that. You can lay out that parties have to have some type of good faith negotiations prior to filing a lawsuit. There can be a mediation requirement. There can be an arbitration provision where essentially that would prevent a party from going and filing a lawsuit at either the state or federal level, and they would have to handle that dispute through an arbitration provision. And kind of the pros and cons of arbitration versus litigation is another hotly debated topic. It's beyond the scope of this, but you definitely want to know, what the game plan is for a dispute if something were to come up under the contract. You see a sample provision here at the bottom. In the event of a claim dispute arising out of the agreement, the parties shall attempt in good faith to settle the claim by informal negotiations, following receipt, specifying the reason. So if you have this type of provision in your agreement, what the net effect is to prevent either party from going out and just filing a lawsuit without trying to have some type of discussions, negotiations about settling that outside of court. Now, I'm sure your knee-jerk reaction is, well, that's perfect. That should be in every dispute resolution provision we sign, in every agreement we sign. And again, it depends on the circumstances. Maybe that's a good thing. Maybe not. Maybe that's for a party who feels like they've been aggrieved and needs some type of relief under the contract. Not being able to go out and file a lawsuit immediately and having to wait that 30-day period and go through those discussions and slowing that process down could be a bigger problem than the benefit that you get. An entire agreement clause asserts that the contract constitutes the whole agreement between the parties and seeks to prevent the parties from relying on anything outside of the four corners of the contract. So, if you have an entire agreement provision in there in your document, what that means is all the other stuff that came before that contract does not matter. If the parties exchanged emails about the contract, it doesn't matter. If someone made a verbal statement, told you, hey, listen, we'll give you 10 days to cure default, it doesn't matter, right? All that matters is what's inside that document. So the entire agreement provision is the legal way to essentially clean the slate of all that other stuff, clean the slate of all the other communications, of all the other documents related to that contract, or any verbal, telling someone, making promises outside the contract before it's signed. That gets that away. And the reason for that is, you're signing a contract, you're signing an agreement. People, and companies want to have comfort in terms of what the obligations are. It'd be really difficult if every time there was an issue that came up, you not only had to go pull the contract, which, as I mentioned before, that can be a challenge in of itself, but having to track down everything else, all the emails that led up to the negotiation of the contract, talking to everybody that was in part of the negotiations to track it down. that would be very burdensome. So it's a way of just kind of giving clarity to everyone that what's inside the document is what governs the relationship. And the sample provision here says, this agreement contains the entire understanding of the parties with respect to the subject matter hereof, and supersedes all prior and contemporaneous written or oral understandings, agreements, representations, and warranties with respect to the subject matter. So again, what's in the agreement is the agreement, and it doesn't matter kind of what the other stuff was led up to that agreement. Now, there's exceptions to everything, right? If there's some type of dispute, if there's ambiguity to the contract or things aren't clear, there are mechanisms or ways that maybe some of that other stuff can get pulled in. But the general rule is whatever's inside the four corners of the document governs the relationship. And then let's see, governing law and venue, another very important provision that unfortunately gets taken for granted. These provide which state laws will govern interpretation of the contract and where a lawsuit will be brought in the event of a dispute. And these should be tailored to whatever the particular agreement is. You can see a sample provision here where the governing laws for Alabama and the dispute resolution are in the state and federal courts located in Huntsville, Alabama. If there's a dispute, this is yet another provision that the parties will immediately look to, especially the attorneys, right? They're the first thing they're going to do is search for the governing law and venue. And it's really important to keep this in mind. I mean, if you sign an agreement, if you're an Alabama company and you sign an agreement with a company that has operations in California or New York or anywhere else, and you agree to not only to their law, which you may have no idea what their legal standard is in relation to certain provisions, but also the venue, right? So the place where a dispute will be resolved. If you sign on to California venue, that means that not only are all of your contractual provisions being interpreted under California law, but it also means that from a practical standpoint, if there's a dispute, you're going to have to go to California to resolve it, right? You're going to have that travel expense and pain and just having to deal with that makes things much more difficult. Not to mention the fact that there's something to be said for home court advantage in terms of where disputes are resolved. So always be aware of what governing law and venue are part of your contract. And this plays hand in hand with the slide we had just looked at in terms of what the dispute resolution provision is. Dispute resolution, governing law, and venue, all of those are critical points in contracts in the event that a dispute does rise. So that's obviously a lot of information, in a very short period of time about contracts. My biggest piece of advice is what I started out with, which is make sure you read your contracts. You want to obviously, if you can, negotiate those on the front end to make sure that you put yourself in the best possible legal position. But even if you're not negotiating the contract, if you're just signing the document, you still want to know what the battlefield is, what are the rules of the road are for what you're stepping into, and that's certainly important. It's good to know what the downside of a contract is before you sign it, so that you're not blindsided by some unknown contingency later. And then finally, ask for help. Please reach out to me or someone else who can help walk you through the contract process, help point out things that you may be completely unaware of, help tell you what's standard and what's not, right, in a particular industry. I think that's very important because in many cases, new companies get contracts the first time and they could be completely fair based on market conditions, or they could be completely, unfair and unmarket based on the current situation. And having someone that can help guide you through that process is certainly very important. But thank you very much for taking the time to watch. If you have any follow-up questions or items you want to discuss, please feel free to reach out to me anytime. And I hope that you found this presentation useful. Thank you very much.